Chair calls Alexander Kim, testifying for House Bill 93 on behalf of himself.
Thank you, Mr. Chair. My name is Alex Kim. I'm actually honored. I read through all the bills filed, and it's good to put the faces with the bills that I've read. I want to introduce myself. I am a practicing attorney. I'm licensed in the state of Texas, United States District Court, and the Supreme Court of the United States. And I've practiced family law for about 6 years. I primarily do criminal defense at this point, but I did have quite a bit of experience with that and with no-fault divorces. And Matt asked me if I would give my opinion on this one. I'm also a vice chair of the Tarrant County Republican Party, and I was a presidential elector this year here in Texas, sitting on the floor in December. There is any empirical study, any study done on children out of single-family homes, all lead to the same conclusion, right? They all show higher teenage pregnancy rates. They all show higher criminal arrest, interaction with police rates. They show lower high school graduation rates, lower college attendance rates. There is no study that showed that children in single-parent homes in any of these qualifiers end up better than children of traditional family homes. Even when you consider and cross-reference these traditional homes that have problems, they have abuse, they have parents that maybe fall by the wayside or are not the best parents, but still, through and through, a dual-parent home has better adjusted what our social norms are based on than single-parent homes. And that's why it's a concern for me that we, if we can, curtail the number of divorces. And that's my frank opinion, what I would like to see. Anything covered right now by divorce by fault is under the statute is already there. No fault divorce for me is a concern because, and he kind of stole my thunder, the previous witness, but this is the only civil suit. This is the only case in the law that you can file in court where the defendant cannot win. All the simple mere piece of evidence by the plaintiff has to be is, I don't want this to work. It is insupportable to me, and the judge grants it. And that's all it is. That is not due process based on what the Constitution, the same oath that we took as attorneys, some of us and all of y'all took as representatives to defend the Constitution of Texas and of the United States. All right. No other contract can be withdrawn unilaterally. Marriage to me, when you take the oath of marriage, you go through the rites. It is a covenant. It's a covenant with your spouse. It's a covenant with the state of Texas. It's a covenant before God if you chose to get married within a church. And at that point, for one person to unilaterally break that covenant to me is unconscionable. This is something where two people enter into it, and I have no problem with two people agreeing to dissolve the marriage. But if there's a problem, one person can't just say, I'm done, can't cry uncle. Now, I do still have many friends within the family bar of Tarrant County, Texas. And from what I'm seeing, talking to these other attorneys, it seems like the primary concerns were, one, an issue of privacy for the children. Now, I know the committee amendment shows that this record would be sealed, and that took care of one of the three problems I saw most often. The second part is, what if the parties agree? And of course, the amendment does have that. If there are no children involved, any kind of agreement for a mutual agreed orders for termination is fine. And the last one I hear is really the oops defense. I was too young when I got married, and I'm just kind of stuck here. I would like to remind this committee that throughout the family code, which you review and you're dealing with, there are countless number of issues where a parent's rights are suspended for the best interest of the child. And there's no doubt about that. The family code over and over again looks at that. Juvenile justice looks at that. The best interest of the child is a primary concern. And when you get married and when you have children, or if you don't get married and you have children, the best interest of the child is the prevailing motivation for this. And the best interest of the child show that having dual parent homes is beneficial to the child. Now, I do want to also say on this one is that there is one thing, if I was on the committee and if I could make a change, on the part this actually would be in line 23. I would actually change it so that that the confidentiality would be waived for not just the court that the divorce was out of, but for any court. I certainly think, Mr. Moody, I'm sure there are many times that you used allegations or affidavits in a different court, in the family court, to help prove up extraneous offenses under 404B on punishment phase. And I think the prosecution should still be able to use that. If there's a pattern divorce or for a defendant to be able to use in his trial, I think this should be accessible, shouldn't be closed just to the court that this was filed in, but in any court proceeding. I feel like this information on the cause for divorce should be there.
Thank you, Mr. Kim. I think your time has expired. Mr. Moody, I think Chairman Moody has a question.
A quick question. You said that these are the only types of cases that a defendant can't win. What does a defendant winning look like in this case?
Well, for one, I would consider for the person who said, I made a vow till death do us part, is
Okay,
duty
but
held.
And I know that we all have our various religious beliefs, and I've entered into marriage in my church, and also went down the county clerk's office, and I can understand and separate some of those two issues. So that vow is a religious vow. I'm talking specifically about the court cases going forward. A defendant in that case, for them winning means what?
Not getting the divorce. That
So-
when the person sues for divorce and says, greetings here, you have been sued, and says, I'm looking for the dissolution of marriage, for them to say, you have not shown grounds why the divorce should be granted.
So what if that person that was talked about in previous testimony does not want to be married to that individual anymore? Winning for the defendant is to force that individual to remain in that marital contract?
Well, I mean, according to the family code, so the reasons for grounds for divorce are going to be adultery, felony conviction, mental health commitment, abandonment, which is where you leave with the intention of never returning for 3 years, or when the spouse does. There's also going to be family violence as grounds. And the last one is non-cohabitation. If you simply live apart without living together for 1 year, those are grounds. It doesn't prevent anybody, and Representative Thierry's hypothetical, for the woman who, cruelty is also one of the grounds. If she can prove mental, and it's not about whether you can prove or not. The law is there to provide the avenue for you to prove in court, in your day in court. But if you say, this person is blocking everything, I don't want them to be married to me, I want to be done with this, you move out. You don't spend the night under the same roof for 1 year, then you have grounds. And that's easy to prove.
After a year. I don't understand, and we all have our different visions of what marriage should be and the things that you need to do to work through if you're going to terminate that. I don't know that this body needs to tell people, if you don't get along and if you don't want to work through those different allegations of fault, that you shouldn't be forced to stay with this person. You shouldn't be forced to continue to be married, because if you walk away and you don't go through the legal process to get a fault divorce, what happens then? You're still legally married. Are there support obligations? What happens? What does that functionally look like? I think this seems very antiquated to me. It seems like we're treating our spouses as property, and these are adults that are entering into these decisions, whether they did so wisely or not.
Right.
And if they choose so, wisely or not, with fault or not, that's not my decision to make for them. Now, there are religious beliefs that I hold personally about their decision and whether I agree with it or not, but that is not my role to play. Right. And so I think that we're conflating the two.
If I may, Representative, Your Honor, the family code is right with instances where one parent, remember, if there's no child involved, we don't have to worry about the no fault. No fault is fine. It's just when there's children involved. But the family code is right with instances where when there are children involved, that the parents are kept in some sort of relationship with each other, whether it be child support, whether it be access, whether about responsibilities as a parent, for healthcare, medical, educational decisions. The law, and if we're talking about constitutional protections, right, on due process, and we're talking about a parent's liberty is somewhat restrained because they are obligated under the law to receive information, to give information, to provide information to the other parent. So if the family code has already restrained a parent in one way, for me to think that forcing them to live apart for 1 year to make that decision that I want to get divorced is not overstepping. We've already crossed the threshold, is what I'm saying. Are we making it a little bit harder? Absolutely. But, I mean, we got married. I mean, we made a promise, right?
I wasn't involved in that decision.
I understand.
Mr. Schofield?
Mr. Chairman. Mr. Kim, sort of further to Mr. Moody's question, his question was basically, what does winning look like, and can you make the other person stay married? And correct me if I'm wrong, but what I seem to be hearing from you and the other witnesses on that point is not that you intend to make the other person stay married forever, but that if it's so easy to get out the front door as quickly as you can, marriages that otherwise might be saved, and as the prior lady testified, were this close to being saved, would go in the gutter, where perhaps if they had to follow the traditional cooling off period of basically not cohabitating for a certain amount of time, that some of those might be saved and the children in the marriage would end up growing up with two parents. Is that more your understanding?
That
or
is
were
my-
you expecting people to have to stay together forever?
No, as long as there's children, once there are no minor children, according to the amended bill, then people are free to do what they wish. My concern is if one parent is committed to stay in, and let's admit it'd be a very hostile environment. It would not be a friendly environment. But for me as a father, I am willing to tolerate incredible situations to make sure I am there every day for my son, to help ensure that my son will be less likely to himself get divorced, less likely to be arrested, less likely to have a criminal record as an adult, more likely to graduate high school, less likely to be a teenage father. All these things are sacrifices I'm willing to make as a parent for my child. And I don't think it's unburdensome when two people are willing to bring a child into a marriage that they never had to get married. They could have children out of wedlock, but they're bringing it into a marriage. I don't think it's unreasonable to expect them to, if you're sure about this, just live apart for 1 year. I mean, that is a current avenue available to every citizen in Texas under Texas law.
Thank you.
All right. Mr. Kim, thank you for your testimony. I think we'll, who had a question? Oh, I'm sorry, Ms. Theory has a question.
Just briefly, again, just trying to get to the pragmatic outcome. Based on the last witness's testimony, what would be different, for example, since unfortunately her husband was the one that committed the adultery, and as she stated, they were this close, but a long time period, I think by her own testimony, went by where they were trying to work it out. All those things took place, so it seemed as though it wasn't just a rushed divorce. And then as she stated, unfortunately, the malfeasance, the bad behavior continued by free volition of her husband's part. And then I think she testified that they actually did separate for a while and they were trying to live in different homes, and then the divorce took place. What would be different if, for example, even when he filed, if he had said, I'm the adulterer, raised his hand and told everybody in the world, what would be different? What would be the different outcome for the children in that situation? Because as you stated, they were still going to be divorced. They were still going to fit the statistics that you quoted, if those statistics are accurate. But by your own paradigm, what would have been different? Because they did everything that you're purporting they needed to have done, and then he still filed for divorce. So if he had outed himself and said, I'm an adulterer, what would be different for the children?
And this is why I personally will never run for your spots. Because when you create legislation, right, the problem is any kind of law, all you can do is you can address the middle 80%. That you have a 10% on each end of the perfect best situation. There are some criminal laws that there is no proper punishment for the heinous nature of the crime. And there are some crimes where this person in no way deserves any kind of punishment. But as legislators, when you create laws based on the middle 80%. And there will always be outliers no matter what situation you take. And my heart breaks for those people that have no way out, no redress. For the person, in order to qualify for a divorce, because they cannot stay in their marriage so much that they live on their own for a year and file divorce saying, I'm the one that didn't cohabitate, not the other person, but me, right? Because the law doesn't distinguish. It doesn't have to be the other person. You can file it on yourself for not cohabitating. Unfortunately, Your Honor, you're going to have outliers in the situation, and my heart breaks for those people and those children, those families that do everything they can, and one person simply says, uncle, says, I quit, I'm done. But if we're looking at the middle 80% in Texas, right, the people that when they are divorced, that they actually have a day in court where they can show they have not met a burden of proof. They're just saying, I don't want to do it, right? They haven't proved any reason, any malfeasance on my part. I've been the perfect wife, the perfect husband. I've been loyal. I've been faithful. I've raised the kids. I've done nothing wrong. But yet this person wants out despite my investment, my commitment to this marriage and to this family. That's the part that I think is tragic.
Okay.
Right, but
All right.
to answer that question, I'm just saying, what would be the different outcome? If she had had that same opportunity in court through the title of the adultery, would you recommend that then they would have stayed married?
Well, all
Because
right,
she
so-
would have been saying, I believe her testimony is that she would like to have stayed married to her husband, notwithstanding
Right,
his
so if
behavior.
the husband had gone and filed and claimed adultery on himself, and then as the petitioner, right, would not affect anything. But it wouldn't affect anything here other than giving the reason why in open court, where you can cross-examine and confront your accuser, right, and your Sixth Amendment rights therein to actually say, no, you didn't do it, or no, you're wrong. But actually hear them in open court through a legal process. If people want to get married through the church and just the church, and that's fine. But if they're going through the state, making a covenant with the state of Texas, I feel like they owe the state of Texas an explanation on why their covenant is now broken and dissolved.
Mr. Kim, thank you for your testimony.
Thank you very much. I appreciate the privilege. and
Thank
honor.
you.